Okay. Okay. So I can't use the speaker on my headset anymore. That's what it is.
Oh, that's the problem. You're saying
Yep.
when you take that off, that solves the issue.
Yeah. And so if I use a different speaker, now it's working. So
When I went to Parma, and I don't know if this will work, because Al Haverkamp's wife is a photographer and she took my other photo.
oh, okay.
President of RIMS, but it's old now, right? I've been using that photo for a very long time. And so, but when I was up at Parma in Sacramento, they took a shot of me at Parma, a professional photographer did, and then it was up on the Parma website and they sent it to me. And so I thought, oh, I wonder if you
There
can
you go.
crop it, you know, because I don't know, there's other people in it, so I don't know if that works, but.
Well, it can be cropped. Yeah. If there's not.
Yeah, because I was going to go to Al and ask him if his wife might be willing to do another one, because it would be a favor, right? And that, certainly I'd be happy to pay her for it. I saw that Bonzel did reach out to reschedule their, I was glad. I thought, oh my God, now that we paid the voucher, we're going to go into like, we don't have to do it land. And I'm like, no, just because we paid the voucher doesn't absolve us of the responsibility. We still have to do. Well, and she's still working there, right?
I know. What I find, Felicia, is that, when we get those districts that tend to go into this rabbit hole when they're presented with multiple issues, they get emotionally reactive. Oh my God.
Yeah. Did too. At the end, they got mad at us. And I was like, what? How dare you? Oh my gosh, all this that's going on. We're trying to help you, incredibly try to help you. Because there's still a lot of emails going back and forth about the Julian thing. And you know what? They're pushing back on whether they need to pay TD or not. And I'm like, because they're saying, well, maybe we could have taken them back to work. Maybe if this and this and this and this hadn't happened. And I was like,
Yeah, well, I know I saw your email, so I'm going to have to go in and sort of, chunk it down. And that's one of the things, I think that's one of the things if we can, start encouraging employers is that, when we get presented with multiple issues like this, it's real important that we step back before we step forward and just say, okay, let's break this down.
Yeah.
Because only if we do that can we start getting a handle on it, because otherwise it's just overwhelming.
And especially when it's a little small, because Julian's case was very complicated. We used it last time in Escondido cases, very complicated. And so it's very easy to get lost, completely lost. That's why there's no judgment. I'm just trying to help them, because you don't have anything, and then you have a case that's so complicated with 4 different disabilities presented that you can't even make, head or tail of it. And then Athens gets completely lost too, right?
Yeah.
Now they're going down the rabbit hole of, well, gee, if we could have responded to the ortho, then maybe we should deny TD, which is going to litigate, right? Because they're going to say, well, you didn't offer them a job back then, right? And you know what they're doing now is quarterbacking now, saying, well, if we could have offered them a job if it was for this, and this. There's a bunch of qualifiers on that, right?
Right. And so that's where it's real important to chunk it down and say, okay, let's just analyze this situation, because that's the workers' comp thing for which the job voucher gets involved. And so based on these issues alone, could we have offered a job and then offer the job? Okay.
Right. Because the attorney is saying, if you're telling me that you could have offered the job, let's offer the job, like right now. And I thought, Julian doesn't want to actually offer a job.
Well, but then, okay, is she medically ready to engage in the job?
Right.
Not different story. Okay. Because under the ADA, we have to take into consideration all things. And so that's why let's deal with the workers' comp injury. Where do we stand with that? And then is she able to engage in the work with or without accommodation? Because that's different issues. And now it's non-work related issues that are preventing her from doing the work.
And Maggie and Maya are looking at that narrow thing where you and I have all the things, right? And so you're right. The chunking it down, I think, just makes it so easy. And Andrea does a good job of doing that. Her little summaries, because like her little summary today, I went all the way back to the beginning. And I thought, oh yeah, I just need to go to Andrea's fantastical, this is
Yep.
my problem, right?
Yep.
Because
Yeah.
and I think she does them pre-IPM for you too. I think
Yeah, she does. Yeah, yeah. So maybe, I don't know, would it be good to maybe offer a class or something like that? Because, you know, I don't
I
think
guess we could talk about the chunk it down on our next time. I just got this, oh, it's 11. I just got this really cool email that I sent you, and it was like the 7 steps of
I saw that.
Navigating long haul COVID with accommodation. But then when I read the 7 steps, I thought, oh my God, we could use them for anything. You could insert long haul COVID for a whole bunch of things. And it's about chunking, right?
It really is.
And I thought, oh, we're not going to talk about this today because we're getting an increase in COVID claims again. No shock. I said, it's not a bad idea to use this as a step off point. This article is just great. And it's all about chunking, right?
Yeah.
The article is the steps you'd go through and how to chunk it down.
Yeah. Because you can see when I respond to some of those, you know, when he talks about to me, it's like, okay, well, from my perspective, you know, and so that's why I said from my perspective, and so let's chunk it down, you know.
Well, that's why I went to you, because I thought they're lost, they're completely lost. And you know, Maya's saying, yeah, I think we need to pay TD, and Maggie's like, I'm not paying TD, I'm denying TD. And I'm not weighing in on that. I'm just saying, I don't think you guys understand the totality of
it. So I'll go back and do an analysis, which I really need to do for that case anyway. I mean, it's been so busy lately that, and I was at a conference 2 days last week that, a little backed up again, but, I do want to get to that one just because of, you know, where we are and the questions that keep coming up about it. So, well,
maybe the IPM summary will help the attorney and Maggie, right? I don't weigh in on whether or not TD should be paid. That's a work comp legal decision. I'm just trying to help them understand the rest of it, right? Because there's more to it.
Yeah. So just so you know, for reasons I don't know, Felicia, and I was on my tablet that day, and I've done many recordings before on that. The recording didn't take for some reason. And so not only did we abruptly end, we don't have a recording, and we got certain pieces of it, but not the entirety. And my VA said, well, I can contact Zoom and go back. I said, you know, at this point, it's not worth my time and effort. I need to move on, and I just need to make sure I've got a good, so I'm back on my regular laptop and stuff like that. So I'm just doing a quick message to the participants, because we did have quite a few people register today, and I
sent it out Friday. I got it Friday, and so I sent it out over the weekend just as a little reminder.
And so just so you know what happens, because I had sent everything to Raymond, got him going on, but when he went to check, and this has happened many times with Zoom before, and I have to admit, I just haven't taken the time. Just 1 second here. Oh, wait a minute. I'm just going to send a quick.
That we're almost ready to get started.
Okay, so I said, grab your coffee. We'll start at 11:05. So anyway, so this has happened before, and what? Even though I go into my Zoom setup, okay, and you know, we've got our regular meeting scheduled every time, and I go in and change the content according to our question.
Right.
Several times it reverts to the last one, even though I've saved it. And I haven't taken the time to go to Zoom and say, why does this do this? And so that's what happened for Raymond. He couldn't send the link out until I had to update the content. I was in a conference Thursday and Friday, so I wasn't really paying attention. And so I've got to get on top of that. And again, we've never had the problem, what, in 2-3 years that we've been doing this now, that we haven't captured a recording. So
that was a new thing that happened on. And I apologize about Friday morning. I felt awful about that, but
you know, all works out. I was able to go back and watch the keynote.
I figured you went back to your conference and it worked out okay.
Yeah. Well, I still missed the board meeting, and I went, you know, because I was at the conference, because I was going to skip the conference to go to the board meeting, and then I thought, I told them I was going to be there. They're not expecting me, so I'm going to go back to the keynote. And the reason why it was important, because I was their first. It was the first live conference they'd had since pre-COVID, but I was the first keynote they'd ever had. And it went very well. They hadn't, you know, and so I was her first keynote. I know the executive director, she reached out to me and trying to bring, you know, emotional intelligence, but not call it emotional intelligence.
Right.
And so it was so well received that people were coming up to me, after all, we have to have you back. And they immediately said, we want a full day of this stuff. And so
Oh,
that's how I
great.
got back. I did the pre-conference workshop on Thursday.
Hey, it's great.
Yeah. And unfortunately, though, it wasn't really well attended, but the participants that were there, we had a great time. And then the keynote the next day, I mean, she was just reinforcing the concepts I've been talking about already. So it was good, but she gave me some good ideas about how to step up my game as a keynote. So that was good.
Oh, good.
Yeah. Okay. So we have 7 people. Let's go ahead and let them in. And I'm going to start off with an apology, and we'll resend that EEO article from last time with this one. And then there's 7 ways to accommodate too. I got to remember this stuff, otherwise I forget.
Well, we'll use that, I think, for our next one, the 7 ways to accommodate. I think.
Oh, not okay.
I think we'll use that for our next meeting. I think we can use it. It's a great structure.
Yeah, I glanced through it, so I'm going to need to take a closer look at that. Okay, so where does it say admit all? There we go. Welcome. Welcome, welcome, welcome. Monday Q&A.
Good morning.
March 13th.
Morning.
Good morning.
Good morning.
Nice to have you here. Great, great. Well, again, Monday Q&A, March 13th, 2023. We have a whole list of topics to cover today. And I first want to say a couple of things. Welcome to all of you, and delighted as always to partner with Felicia Menta. We have fun getting prepared for this and fun doing it. So thank you for the opportunity of sharing our experiences and our knowledge. Many of you who may have participated last month realize that we had an abrupt ending, and we tried to resurrect it, but didn't work. And unfortunately, even the recording prior to that was interrupted in reasons I don't know. And so we were not able to recover a full recording, and do apologize. So taking steps to ensure better signal, better Zoom, etc. And so we will be sending out the article that was referenced last time so you can look at it. And we'll certainly take our steps to fine-tune the technology moving forward. So thank you again for your patience. Thank you for being here. Well, we have a whole host of things to talk about today. And do encourage you to put your questions as we go along into the chat room. And we'll be happy to take a look at that. Oftentimes we go to the very end of our time because we have no questions. And so we just take our time up talking about stuff, because I think Felicia and I could talk about many of these things for a good long time, right, Felicia?
Yes, absolutely.
Yeah. So I'm going to just share with you what we're planning to cover today. We continue to have both interesting case law as well as interesting local cases that can teach us a lot if we learn to chunk it down. And that's one thing I want you to keep in mind as we go through today's program, but also when you're presented with an employee's medical condition in the workplace. It does become complex when there's industrial and non-industrial conditions. And that's going to be our first topic today, the chicken or the egg, because when we're dealing with all conditions we might be presented with, it gets very difficult to sort out, just what we need to do on the workers' comp side, but also what we need to do on the ADA and VHA side. And then one of the things that have come up a lot lately too is we've talked about fitness for duty in the past, but how do we select the best facility? Where do we go when it comes time for fitness for duty? And we both have had several of recent times, so we'll share some of our perspectives there. And yet, again, there are some clear-cut criteria that we can consider if we know what we do. And then what about leave? Leave is a form of accommodation, and just what kind of leave do we tap into first when we realize that an employee cannot continue in their modified work, or if modified work is available and alternative work is not available. And then, that proverbial sentence, read the small print. And we have a situation of where some additional comments are made on page 2 and got overlooked, and it changed the trajectory of the entire case. And then what do we do when we do have knowledge of risk factors that may prevent further harm or injury to the employee with a medical condition, as well as potentially others? And this knowledge of risk factors really becomes of importance under the Americans with Disabilities Act. When do we move forward, and when don't we move forward? And then lastly, the area that we hope to touch upon is sort of like reading the small print. what observable behaviors are we seeing that are maybe different from what the employee has demonstrated before, and what do they mean? And so we'll dive more into that. And again, if we happen to meet our time, by 11:45, 11:50, we will then just carry over our topics into the next time. But at least you have an idea of where we are today, where we're going, and where we may be next time. So let's kick it off, Felicia. I know we've got some great stuff to cover. And so what comes first, the chicken or the egg? Industrial and non-industrial?
Well, I thought what I would do is start with an actual case presentation, and then we can touch on all 5 or 6 of our points, however many we get to, because they're all rolled up into this case that was a real case that occurred in February that I thought would be great as an illustrating example. And I had to make notes because it's a little complicated, so follow along with me. So we had a 70-year-old bus driver who was working over the weekend on a Saturday. I think it was a field trip. He was finishing out his shift, and he had pulled out of the bus, and he was bringing his personal items from his bus to the car, still on district property in the bus barn parking lot. He passed out. While doing this, he fell to the ground. He was unconscious for a few minutes. He then came to, and he called his wife. Luckily, his wife then called the transportation director, his boss. The director called 911. The bus driver was taken to the emergency room. The transportation director said the emergency room wanted to admit him overnight for some testing and observation. But the employee got tired of waiting and decided to leave. Against medical advice, left the hospital without receiving a medical discharge, a release note, or any paperwork at all. The district had the incident tape fall on tape because of surveillance cameras that they had. So that was available. The transportation director called risk management. Great step, right? Asking for guidance. Risk manager, because the employee wanted to return to work, driving a bus, then like the next day. The risk manager recommended that before discussing return to work, they refer him to an occupational medical clinic. The transportation director referred him to Concentra because they do their pre-placement physicals and their bus driver, what we call group 3 evaluations and clearances for the bus drivers. Concentra wrote a note releasing him from care to return to work only for the contusions and abrasions sustained in the fall. On page 2, the fine print, they said, small notation, they could not treat for the syncopal episode that caused the fall at work and directed the employee to their personal physician. That was a small print on page 2. Page 1 was a full release to return to work. The employee went to his primary physician at Kaiser and told them it was work-related. And they said they could not see him because he needed to go to an occupational medical clinic. So around we go, right? And KOJ. The employee wanted to return to work with the Concentra full release, but the district was concerned. So they put the employee out on paid admin leave while they sorted out and got clarification on the return to work status. The district was considering what is best. Fit for duty, work with the primary to get more testing. What about release to return to work? If he had stayed at the hospital, he would have received the testing needed for the clearance to return to work. I also want to say that sometimes the hospitals do call DMV to notify them of all syncopal episodes and seizures. This is something that's regularly done behind the scenes that most employers don't always know about. Notes I wanted to add, the clearance needed for the commercial bus driver license, group 3, is normally done at Concentra. and they also report to the DMV. The hospital told him he called the hospital to try to get a full release back to work, and they said no, because we didn't finish your treatment. You need to go to your personal physician at Kaiser and obtain a clearance. And Concentra told him they could hold the paperwork for a very short period of time where he went so he could go get clearance. Otherwise, they were going to have to submit the paperwork to the DMV, which was going to put a suspension on his commercial driver's license, which would be a real impediment to returning to work. So that is my case study to start us off with our discussion points.
Yes. Yeah, quite a series of events, and we have all kinds of things going on. And so that actually jumps to our number 4 point, read the small print. And I have to admit, I've been in situations too of where, I get a medical thing, but I didn't realize there were additional medical reports that told me more information. So I have to be conscious of this too. But in this case, clearly page 2 was overlooked. And so make sure you're looking at those things carefully. So Felicia, was it appropriate that the employer consider chunking it down? So on the physical injury, that it was part of the workers' compensation claim, he was cleared with no limitations, no long-term disability for what he was treated. However, we had this underlying medical condition that led to the fall that needed to be evaluated separately. And so that's where, again, the employee left early treatment, but then got evaluated at Concentra, but then mistakenly, unknowingly, not realizing the differences, misinformed his treating physician, which led to a prevention of further treatment because of the work status. And so
in order to cure that, we had to go up high. We had to go to our account reps at Kaiser and explain that the fall had been seen at Concentra and dealt with. It was really, he didn't break it, fracture anything, or sustain a head injury, which we're very happy about, right? The fall for in this particular instance was relatively minor. That was the work comp claim. We cover the injuries on the way to the ground when you have a syncopal episode or a seizure or low blood sugar level, whatever causes you to pass out. That underlying condition has to be treated over in HIPAA in your non-industrial, but he didn't know to tell his primary that what he wanted to be seen for was the non-industrial condition, because to him, this happened at work. So it was all a work-related injury, completely understandable, right? Very confusing. And so the language and there was a lot of education that had to happen between the district and the employee on what to say to his primary doctor. And we were able to get him into his primary doctor to continue on with that testing that was necessary to get it over.
Right. Yeah. So, we know that the employer put the employee on paid administrative leave. Was that really the appropriate step, or what options existed?
It's always good to talk to your employment attorney when you get into these kinds of matters. I think in this particular case, there was a lot of confusion, right? Between him walking out of the hospital AMA without any release at all. So then they had no idea what was going on. They didn't know what caused him to pass out. Obviously, we have to take the most cautious approach when our employees are in positions where we're liable for children, right? In a bus driver, we have a super high responsibility for safety. And so I think the district took the most conservative approach and put him out on paid admin leave while they tried to clear things up between Kaiser and Concentra and what they didn't have from the hospital. The employee went to the hospital to try to get information, and they told him, no, we're not giving you anything. You didn't get anything. You left early. You need to go over and start again at your primary. Concentra did the right thing. They evaluated the work injuries because that's the only thing that they were covered to evaluate. And on the page 2 fine print, they talked about the non-industrial, because that was really like what was going to keep him from returning to work, because there was no clarity on that, right? And so whether you're paying sick leave or whether you're paying paid admin leave is something you're going to carefully walk through, and then usually you're talking to counsel about that.
Yeah. And so going back then, from an employer perspective in a situation like this, again, familiar with Concentra because they did the DMV evaluations anyway. However, since this employee had Kaiser as his health insurance plan, what might have been a more appropriate choice in this case? And that's why we're talking about what do we do when we come to picking further fitness for duty, or how do we evaluate this?
Right. And I feel like this case presented so much complexity. I completely understand why the transportation director said you need to go to Kaiser because that is, or you need to go to Concentra because that is where we get our clearances for your commercial bus driver license. And she was realizing we were going to have a problem there. But also that was a fine line between also going to Kaiser, because Kaiser on the job, the one thing about Kaiser on the job, when you have a Kaiser Live that has a work comp injury, they can see everything. They can see all their records. They would have been able to see everything from the hospital. They would have been able to see everything from the admission and what happened and how far the hospital got in treatment, whereas Concentra couldn't see any of that. So I'm not saying it was a wrong decision to send him to Concentra, but Kaiser on the job might have been a better place to start because he was a Kaiser Live and he had an underlying non-industrial medical condition that was not known to us, right? Because it's HIPAA protected. And that might have been a faster way to get him to get some clarity. Right.
And so that the point we wanted to make here then is that, well, you might have your preferred, occupational med in a facility, like in this case, because of DMV clearances. It's helpful to take a look. Well, what is the employee's health insurance plan in the event that there could be an underlying condition? And so that would apply whether it's Kaiser or, or some other, healthcare provider. And so now you made reference, Felicia, to that you had to sort of go, above. And so describe a little bit more about that in order to sort of get the resolution on the non-industrial condition.
So everyone that's a Kaiser Live knows that the very first thing that happens when you walk into Kaiser ever to make an appointment, schedule appointment, is they ask you, and it doesn't matter if it's urgent care or wherever, did this happen at work? And the reason they ask you that is you're not going to go see your regular primary. They're going to direct you to Kaiser on the job. And this case, he would have gone both directions, right? Once he would have started at Kaiser on the job, and then he would have gotten to his Kaiser group medical physician to try to figure out what had happened that caused the syncopal episode. Because with a bus driver, we're so concerned about those because the liability that, he could have passed out while he was driving. He passed out 15 minutes after getting out of the bus and walking to his car. I mean, that's how scary this incident was, because he was completely unconscious, right? Like he just completely passed out and was out. So it could have happened while he was driving, and that's why. But I do think that there's only, when you think about all of our occupational medical clinics, and we're contracted with all of them in San Diego County, there are only 2 that also do group health, right? That are group health systems, and it's Sharp-Steele and Kaiser. So I just think we should have a discussion in the beginning that if it's a Kaiser or a Sharp Live, we might want to consider going that direction than going where we normally send people when we have these conditions where they're overlapped. This was both, right? It was a work comp injury and it was an underlying group health condition.
Yeah, great. Yeah. And I think what I'd like to do, I'm going to jump around a little bit given the order of the topics that we gave, because I think this is a good segue into this other case that we're dealing with, that there were actually 3 medical conditions, one of which was work-related. And this is where, Felicia and I want to talk about chunking it down. And so, Felicia, say a little bit more about, that particular case and sort of maybe a little bit about the chronology of it. I know of it, but you know it better. And so I think that would be helpful to hear your perspective as far as the non-industrial that led to the, didn't lead to, but I'll let you take it from here. I'm not going to muddle it with my perspective.
We have another really complex case that has a lot of interesting aspects to it, where this was a food service worker who was working at the district and was having a non-industrial eye condition that really rendered her almost legally blind. So she was trying to work with this condition, but just was unable to. And so her eye doctor took her off work completely. Non-industrial non-industrial condition. She was running out of a lot of her leave. And so while this was happening, she filed 2 workers' comp claims. The first workers' comp claim was an orthopedic injury, a continuous trauma for standing on her feet and working with her hands as a food service worker, which we see quite a bit of, actually, repetitive stress injuries in the food service area. And then there was also a continuous trauma stress claim filed, a psych stress claim specifically against the supervisor that this individual works with, saying that they were unable to work with this person anymore. So then on top of the note, off work completely, they had an orthopedic note with work restrictions, that they could work with temporary work restrictions. And then they also had a psych stress note that they could work, but they could not work at or around their supervisor. And this is a small district and a small food service department. So you almost can't work without working around your supervisor. So.
Yeah. So I think, what's important to recognize is that the employee's eye condition kept her off of work until she had a certain surgery. Right? Yeah. And so once she had her surgery, which unfortunately carried over into this period of when she filed her workers' comp claim, which weren't they on delay too, because it was so much later than the alleged date of injury. So they had went to the 90-day delay.
Yes.
So then that further caused. So what motivated her to finally, file these claims was unknown. But then 2 is that recognizing, well, she couldn't come back to work until she had the surgery. So that would have to be reevaluated after appropriate recovery. Meanwhile, these 2 claims are filed. And again, for good reason, it's on delay while the rationale for the claims are being evaluated. But when the limitations came, then this is where chunking it down, even though she was already off on the eye condition, under workers' comp, we still need to evaluate in a timely manner, given what we know. Mm-hmm. Given this situation, given this injury, or in this case, 2 work-related injuries, could she be accommodated? And so, and we recently just had the IPM, and so what was determined is that given the nature of the orthopedic limitations, no, she could not be accommodated in her usual work because of the physical demands that were part and parcel of it. And then 2 is that, could she be accommodated given the psych claim? And because she was, apparently this is a longstanding issue between the 2 anyway, but because, it's a small department, then she could not be accommodated by not working for that person or in close proximity. So we were able to verify that, no, this person could not be accommodated irregardless of the eye condition. And so this is where it becomes really important to chunk it down per each medical condition and in knowing the different laws. One thing on the workers' comp, but then we have to go back when the eye condition resolved. Could she have come back to work with the eye condition after she recovered? Absolutely. Under the ADA and FEHA, but it was the other 2 medical conditions that precluded her. And so she is not going to be accommodated at this point. Are there any other facts to that case, Felicia, we should talk about?
I think what's interesting about the case was because all of the notes were coming in simultaneously, it became very, very confusing because at one point the eye condition, she was off work completely. Mm-hmm. And at some point she had a lifting restriction, which really confused them because they felt like that was an orthopedic restriction and didn't really go with the eyes. But a lot of times when you have surgery or when you're having problems with your eyes with pressure, they don't want you doing a lot of lifting. So the lifting restriction actually was for the eyes, not for the feet injury, but it became overwhelmingly confusing rather than, like you said, keeping all the conditions separate and then making decisions. Yes, we can accommodate this. No, we can't accommodate this. Yes, we can accommodate this. And then what the overall decision is, right? Because there are rules in workers' comp that even if you're off work for a non-industrial condition, if you couldn't have accommodated the orthopedic condition anyway, or the psych condition, workers' comp might have to pay TTD, even though they're off work on what we would call sick illness for the blindness. So it's where the rules in workers' comp really make gray all of the return to work decisions on the ADA and FEHA side.
Yeah. So it can be complicated. And I'll just share with you a tip that I do frequently when we have these multiple kinds of conditions and this intersection of laws. I'll actually do a visual chart. I'm a very visual person, and hence the video on what we're doing here. But I'll start off, employee, and then school district, up there, and then do a vertical line down and start breaking the boxes down. And that's where I insert, what is the body part or what is the nature of the injury for each one? Is that work related, non-work related? What are the sequencing of dates in terms of, looking at that? And then you get a nice visual, you can sort of cross section. What determination needs to be here? What determination needs to be here? What determination needs to be here? Because if we take a look at the whole picture, we get confused. It's overwhelming and it's hard to sort through the facts. And that's where we can make reactive decisions that are not founded in factual information. It's like the knee-jerk, reactions like, oh no, we can't accommodate. It's like, well, wait a minute, we've got 3 laws involved here or more. And so let's break it down and which law is saying what. So.
And I also wanted to add on that psych stress claim, a lot of the school districts have a lot of difficulty accommodating restrictions that are like this. This restriction was worded both by the primary treating physician and by the QME. It was worded the same way that the employee could return to work because of the psych stress, but could not work at or around that supervisor. So that means it can't work at that site. It can't work in that department. That doesn't mean that could not be accommodated. A lot of times that restriction gets a real emotional component to it, right? Because that is that person's boss, right? And so that just becomes a very difficult situation because the only way that they could have accommodated that is moving her into a completely different department where she doesn't report to that supervisor.
Yeah. And I'm going to add a couple things before we address a couple more of our points. So these are based on a couple of recent cases as well, in that we had an individual who was hired into a position in February 2022. And I think as most people would, anticipate, there's a degree of public speaking in almost any educational, professional position like teaching and special ed and things like that. And there was a high degree of absenteeism, no medical condition. But then when it came for the opening of the school year and they were supposed to do some public speaking, panic attack occurred. And so this has been very interesting too, because they had knowledge of her medical condition. And had they known at the time of hire, they may have, said, can that be accommodated or not? And that was never even addressed. And then she came back and later claimed it was a workers' comp related. It happened at work, but again, it was a pre-existing condition. So she's been on the delay process, finally saw, an evaluating doctor right before Christmas, who came back and said, temporarily, totally, or partially disabled until she can be removed from any public speaking in groups. Well, there was no definition of the size of group. And so when we, that's the only medical information we have. We have nothing else that precludes her from work except for that. Well, speaking before groups cannot be accommodated, cannot be eliminated from her job. And it's sort of a quagmire because it's still on delay, QME coming up to evaluate, is it work related or not? And then this is another important point because the QME will help finalize whether it's work related or not, but may not necessarily give us functional limitations to try to accommodate. And the employee claimed that she could speak in smaller groups like IEPs and other things. But it was like, that was contrary to what the doctor was saying based on the information the employee had given to the doctor. So that was another very interesting thing as far as chunking it down. But frankly, she'd been absent so much in first year of her contract that she was not fulfilling even basic terms. And so, that's one to be seen. I'll have another one that just, go ahead.
I thought in that instance, it was interesting because I think she hadn't even met all of the requirements, right, for the work that needed to be done in the contract. And I think the decision is being made to possibly non-renew the contract because of that. Yes.
And so one of the suggestions for her was that, being in this line of work does require, some, public facing speaking. And so perhaps your treatment plan can work on overcoming your anxiety to do that, because it can be overcome, but with supportive services and treatment, But to expecting to accommodate something that's sort of basic to that kind of job is not a reasonable accommodation. Again, we don't remove essential functions. We restore the employee to performing all the essential functions of their job to the level of performance or productivity required within the business context. And right now, in this case, again, a small school district, the director of the program was covering for her in all these different aspects. And so she was doing 2 jobs. And again, we don't do that on an ongoing basis. Right. I do want to bring up one other one that's sort of related to food services, Felicia. Again, this is a recent IPM, and the employee is an extremely, hardworking employee, hardly ever is absent, said buku hours of sick leave and vacation leave, has been like a 25-year employee. So that does mean she's getting up there in age, but she did have a legitimate work-related injury in that she was kicked and fell to the ground and so forth, and came back to work fairly quickly, even after surgery. And came back to work fairly quickly, then did have surgery, and then came back to work again. And they were modifying her work because she was not at maximum medical improvement. And so when I got the referral, I was told, oh, this should be pretty quick. She's already been working modified duty, and she should be able to continue. Well, when we got into the interactive process, it was learned that she had not been doing all the essential functions for this entire time. And she was not performing about 30% of the work, which meant the work was falling to the shoulders of others, or her supervisor was stepping in to do things. And so, and given the nature of the limitations, I think the lifting was pretty significant and no reaching above shoulder level. Well, I think the lifting was like 10 pounds. And so, trying to accommodate that in the kitchen services was not viable. And so unfortunately, as I was going through this, she goes, well, yeah, I don't know that I can go back anyway. And yet she was trying to stay in there because she was such a loyal worker. The employer certainly did not want to lose her, because she was such a, but, continuing to, have others perform 30% of her job is not a reasonable accommodation. And so unfortunately, we're helping her shift into all the other benefits she has through, she's got, 400 and some hours of sick leave, so she's going to be carried by sick leave for a long time before she even touches into the 100 days under the Ed Code. And but we let her know she's certainly eligible for retirement, and so she felt pretty good about it at that point. But we had to sort of ease her out of the job, but just saying that's not okay. So be mindful when there are accommodations being made at the local site and you don't even know anything about it.
That didn't even come up. The district didn't even know that the coworkers were helping out with the job duties and that the supervisor was doing a large percentage of the job until the IPM. We have another IPM coming up soon that is being scheduled, I think this week or next week. And it has a very similar feel to it in that the employee has been at work for a very long time, basically self-modifying, and just kind of lost track of it, right? And so when we were trying to schedule the IPM, the districts were saying, well, she's working. So of course, and I said, well, okay, these are the permanent work restrictions. They were like, whoa, okay, we have to talk about that. Like we didn't even know that, right? So the work restrictions were sent from the claims examiner over to the district, but they just either didn't register or they didn't look at them closely, or they didn't really click that she's out at a site doing everything, right? And that she has these work restrictions. So then they were like, oh, well, now we have to talk. But they were thinking, why do we even need to meet? Because she's working. So there's no problem.
Yeah. And so both of, your example, Felicia, as well as the one that I provided, both address knowledge of risk factors. And so what really triggered my shift in thinking, facilitating this meeting just last week, was that the employee was reporting high levels of pain. I mean, 7 to 9 on our scale of 0 to 10. And so it's like, if it's around 5, that's usually, sort of doable. But she had been working all this time with ongoing pain levels, and she would basically go home and crash. And so it's like those kinds of pain levels, while continuing to work, does put her at risk for additional injury or exacerbation of her existing condition. And when you have that knowledge, unless you can mitigate or remove those risk factors, you can't. And we couldn't mitigate or remove the risk factors of lifting and reaching above shoulder because that's part of the job. And so, and so it was really the pain level that really, it's like, you've been working like this? And she was, well, yeah, I've been worried about, how much pain I'm in. And that was, I just felt that was knowledge of risk. And it's like, I said, from my perspective, I am not comfortable with, your continuance of working in this environment, because of what I now know. And that's sort of what you're talking about too, Felicia. She's got, the employee's got limitations, but that, again, the district office may not even know what's really being done in the job site. And that's why, again, my emphasis to everybody is use the interactive process as an exchange of information. You need to, get to know what's going on for, the department, what's going on for the employee, and can we realistically accommodate it? And again, you've documented it from the ADA side, which is your biggest risk factor in not doing it, because the damages are far greater under ADA than they are workers' comp. But then you've also clarified if it is work related, you've clarified the workers' comp aspect. Can we accommodate or not? And that goes back to the point, Felicia. We know there's several, and probably many more we don't know about how employees have continued to work, but because the interactive process and the clear delineation of can this person be accommodated or not have led to the employee continuing to work and still receiving the $6,000 supplemental job displacement voucher, right?
Yes, we've had several cases of that where we just haven't been able to schedule the meeting in time to meet the 60-day requirement for the workers' comp, and unfortunately have had to pay a $6,000 voucher even for employee who is still working and who may probably be accommodated. I thought I'd make a big circle and go back to my bus driver case from the beginning, if it's okay, and just add when the transportation director went to risk management, which was so wonderful. This all happened within the span of a day or two, right? There was a lot of exchange of information going on between the transportation department and risk management. When their question to me was, oh, wow, what do we do? Do we go to the hospital and try to get a release? Do we go to a fit for duty to try to get a release, which you and I know is going to take 60 days, probably, and be very expensive. Do we go to the primary doctor and try to get testing done to get a release? What do we do now? I didn't lay it down right away, but I thought of it after you and I spoke about it. I laid down also we can do an IPM, and they were like, well, it's way too soon. And I said, we could do an IPM because there's enough confusion and you're off work right now, but you have a release and you're confused. You could interact now as an education process, right? To talk about all these problems that we're having and why we can't put you safely in a bus. Because when we talked about those unusual employee behaviors, in that particular case, where were the unusual employee behaviors? I walk out of the hospital and I passed out and I don't even know why. And I didn't get treatment to get clearance, and I want to go back and drive a bus with kids. Well, what is that about, right? That's really scary. And then second unusual behavior, here's my first page of my Concentra full release. I'd like to get back into a bus, right now and drive kids after I just passed out 2 days ago in the parking lot. Those are what I would call warning signs, right? That's unusual employee behavior. We have high risk, right, with kids in lots of areas, especially in bus driving, where we have to take the absolute most cautious approach.
Absolutely. Yeah. It always goes back to the students. And that's where, several cases I've come into in contact recently, always take it back to what's our purpose here? What's our end objective? And it's to serve the student. And so always evaluate it. We have to take a look at things on a case by case basis, but it's also important to say in the bigger picture, how does the job fit in? And it reminds me, Felicia, of another case we recently talked about, and I'm going to touch on it. I know a couple of people are here that were part of that meeting, and in confidentiality here, but I don't want to just talk about some of the facts here. In that, how important it is to confer with your legal counsel, with Felicia, perhaps myself if I've been involved in IPM. Because the more minds that we can take a look at this issue, because everyone's coming from a slightly different perspective and can weigh in, the better. And so I know we've had an employee with a medical condition, longtime worker, again, had done things throughout COVID and so forth, did file a workers' comp claim long after the supposed date of injury. And so it triggered a couple things. One, investigation delay because it was filed so many months after the alleged date. And then two, it was sort of a multiplicity of issues of where, is there stress involved or not, and it got the physical side of it. But one of the things too is that, it had been observed there had been a change of behavior over the last couple of years.
Mhm.
He was now becoming more difficult to be redirected in job assignments, as just any school district has the right to do, and was becoming sort of more obstinate with that. Now, those are early warning signs, but I know that we all walked away from our last IPM concerned about the agitated behaviors we saw in the IPM. There was also a language interpreter that we all didn't feel real confident that information was being translated appropriately. And so now it's sort of a recognition he cannot be accommodated, even though he's not at maximum medical improvement, but at least we're clear in that. Unfortunately, he's running out of his 100 days, so now that's going to be a blow, and possibly his workers' comp claim, it looks like, may be denied. And so a cacophony of bad information or negative information all coming at once. And so how do strategically lay this out so that we don't produce, a workplace school violence incident, because that's a concern that the employee's behavior seems unstable.
There have been a few cases that I can think of where you're right, longtime employee, what we'd consider a very loyal employee, and a behavior shift where their attitude changes pretty dramatically. And obviously, folks that are living in HR that live in that are handling comp that also live in HR. You see this, in HR sometimes too. And so these are things that we look at and kind of track when we're trying to make decisions.
Yeah, and so it can be, complex, as we well know, and some are very straightforward. And so, we hope that all of you find, this digest of live cases at the local level, in fact, to be helpful and illustrative in terms of how you might go about your management of your employees with medical conditions. And, put your heads together locally, as well as seek out and, draw on resources like Felicia and myself. And, because we're in this together. I've often said lately, it takes a village to manage an employee with the medical condition in the workplace, because there are so many different facets that come involved at both the state and federal level, and multiple things on the state level between workers' comp, FEHA, Ed Code, and on the federal level, most importantly, the ADA, but then also FMLA that comes into play at times. So thank you all for being here. A couple of words. Felicia, tell them what we have coming up next in April.
We have had a rise in COVID claims since the end of the supplemental paid sick leave in California, which we were kind of anticipating. I think I get a COVID claim, work comp claim every day now, whereas we weren't seeing them very much at all. And we do have some people with long haul COVID that didn't file work comp COVID claims. So we are going to be talking about chunking next time, and steps to be taking when we're doing our interactive process meeting, and things that can apply to COVID or long haul COVID can apply really to lots of different medical conditions. So
absolutely. Yeah. And I would just say, not just medical conditions, but I've been involved in some religious accommodation issues. And so it's the same thing. I had two really significant cases back in November, and working very closely with legal counsel on both sides. But we had to do sort of a historical review going back to the, freedom of speech and then the evolution of laws and protections, throughout the present time, and some of the unique challenges that school districts are dealing with, that one law and protections sort of contradict the law and protections on another level. And so where's the happy middle ground there? The other thing on the concept of chunking is that we just have come about with a brand new article on 7 ways to accommodate. And so we're going to use that as sort of a backdrop for next time too. And so make sure you've registered. You can register all the way ahead. We're scheduled, I think we go dark in July, but then we're scheduled all the way through to the end of the year. And again, there will be a recording release within several days. We'll provide some resources that whenever it's available and pertinent to our topics. And because our recording from February didn't work out, I will send out the supplements that we intended for that recording release with this recording release. But remember, it goes back to that. So anything else, Felicia?
No, I think we covered it. We covered a lot.
We did. We got through all 6 topics and sort of were bedded in the case analyses. And so we hope you found that informative, valuable, and please let us know. Let us know if you have specific questions that you want us to address. We usually meet about a week or 10 days ahead of time to prepare for each one. So there's time. Let us know. And particularly if you have a unique case you'd like to have analyzed, of course, confidentially, what a great place to do it and everyone can learn. Okay, so over and out, folks. We look forward to seeing you on the second Monday of April. And meanwhile, live and learn and grow and use what you learned today to your own challenging, complex cases. Thank you.
Nice to see you all.